Namaskar. In today's case note, we shall be taking up one of the most delicate issues that came across before Honorable Delhi High Court with regard to removing or blocking the offensive content from the online platforms in the case of X versus Union of India. Internet never sleeps, Internet never forgets were the opening lines of the judgment authored by Honorable Mr. Justice Anup Jairam Bhambani. So without further ado, let's get into the judgment. Now, the relevant facts pertaining to the judgment were that the petitioner's photographs and images posted on Facebook and Instagram were taken without her knowledge or consent and unlawfully posted on a pornographic website by an unknown entity. It was alleged that the petitioner's photographs and images have become offensive by association. Petitioner alleged that her social media accounts had privacy settings activated, yet they were compromised and her photos were posted to a pornographic website. The petitioner claimed that by posting her, although otherwise objectionable photos on a pornographic website, the errant respondents have ex facie committed the offense of publishing and transmitting material that appeals to prurient interest and tends to deprave or and corrupt those who see the photos. This was a violation of Section 67 of the IT Act. The petitioner further claimed the irresponsible parties placed captions to her photos, which further violates the IT Act and Indian Penal Code. Now, with regard to the procedural history and how the hearing was conducted in the preliminary stage, the petitioner claimed before Honorable High Court that she had filed a complaint on the National Cyber Crime Reporting Portal and with the jurisdictional police, but to no avail. Because of the authorities' delay, the images acquired 15,000 views within a week of being posted. She thus approached Honorable Delhi High Court seeking the redressal of her grievance. It would be interesting to note that since the respondent number 5 and 6, a pornographic website and an unknown entity were not identified in the petition, no notice was sent to them. Considering the nature of the case, it was ordered that the two respondents were not required to be heard in the current proceedings, but they may defend themselves against the state respondents, including the jurisdictional police later. During preliminary hearings only, the authorities submitted before the court that while they were eager to remove the petitioner's offensive content, they could not guarantee it. The petitioner complained during the hearings that while the court was seized of the matter and interim orders for immediate removal of the offending content from the errant website had been directed, the errant respondents and other mischief makers had redirected, reposted, and republished the offending content onto other websites and online platforms, nullifying the orders of telecommunication. So before Honorable High Court, the issues in hand were that when a party seeks a court relief to remove offensive or illegal content from the web, what directions must a court grant to make its order implementable or effective? To which parties must such directions be issued? What steps must law enforcement agencies take to implement court orders or directions to guarantee that offending content does not resurface or remain on the web at the instance of the errant parties and that such parties do not evade compliance with impunity? The relevant legal provisions which were scrutinized for the judgment were from Information Technology Act 2000 as amended by Information Technology Amendment Act 2008, Information Technology Procedure and Safeguards for Blocking for Access of Information by Public Rules 2009, Information Technology Intermediary Guidelines Rule 2011, Information Technology Intermediary Guidelines and Digital Media Ethic Code Rules 2021. So talking about the arguments on behalf of the parties, looking into the technicality and complexity of the issues in hand, Honorable High Court deemed fit to appoint an amicus curiae, Dr. Pawan Duggal. He made the following submissions. First of all, he had drawn the attention of the court to the relevant provisions of the Information Technology Act 2000 as amended by Information Technology Amendment Act 2008 and to the Information Technology Procedure and Safeguards for Blocking for Access of Information by Public Rules 2009 and Information Technology Intermediary Rules 2011. So while the proceedings in the present case were underway and the council had made detailed submissions regarding 2011 rules, the central government superseded the 2011 rules by making the Information Technology Intermediary Guidelines and Digital Media Ethic Codes Rules 2021. So it was submitted by the Learned Council that what is clear from the enactment of 2021 rules in supersession of the 2011 rules is firstly that the central government has sharpened and expanded various aspects of the liabilities and obligations cast upon intermediaries to deal with unlawful content. Secondly, specific timelines have been set down for dealing with complaints by users or victims relating to unlawful content, more particularly the time for taking action for removal or disablement of access to prima facie unlawful material has been effectively reduced from 1 month under Rule 3 of 2011 rules to 24 hours under Rule 2 of 2021 rules. Thirdly, it has been expressly laid in the 2021 rules that omission on the part of an intermediary to remove or disable access to the unlawful content would revoke the exemption from liability enjoyed by the intermediary under Section 79 of the IT Act. Having noted the underlying statutory architecture in India relevant to the questions in hand, thereafter, attention was drawn as to how international courts have viewed intermediaries such as ISPs and search engines. This is important because search engines and other huge technological businesses which administer the internet operate internationally. There is no reason intermediaries should be handled differently in India than in other countries. Also, certain judicial precedents in India, like Swami Ramdev and others versus Facebook and others, YouTube versus Geeta Shroff, ABC versus DEF and others, and Shreya Singhal versus Union of India were also referred. The intermediaries and who are the intermediaries, also what are the exemptions for the intermediaries in view of Section 79 would be later on dealt in the judgment, and I shall be referring to them at a relevant point. Now, on behalf of Delhi police, it was argued that in order to ensure successful removal of offensive and unlawful content from the internet and to prevent such content from being reposted, retransmitted, or republished, intermediaries should be directed under Section 79, subsection 3B of the IT Act to remove such content identified through unique identifiers such as the URL, that is Uniform Resource Locator, account ID, account name, and intermediary ID. The Delhi police also urged intermediaries to share unlawful content uploaded, metadata, data dumps, basic subscriber information, access log, etc., to apprehend the perpetrators and break the chain of repeated uploads. Social media platforms, instant messaging services, email services, etc., sometimes ask law enforcement agencies to issue letters rogatory and resort to prolix remedies under mutual legal assistance treaties, and even when unlawful content is uploaded from an Indian IP address, it was complained by Delhi police that it delays obtaining information and material to bring illegal content uploaders to justice. On behalf of Google, it was submitted that a search engine was not the entity to which the directions were required to be passed if offending content is to be removed from the internet. And if such directions are passed, they must be only qua specific content, which had been duly adjudicated to be unlawful under special provisions of applicable law, and no blanket directions or order that required proactive monitoring. Honorable Supreme Court, according to Google, held repeatedly that an intermediary cannot judge the legitimacy of online content as held in the case of Shreya Singhal. It was also argued that it was not the legislature's intention to task intermediaries with policing or monitoring content in the guise of due diligence, and that Google is statutorily exempt from liability resulting from third-party content indexed on its search engine, and its role is limited. Further argued that it is technologically impossible by the search engine to monitor illegal content when the issue was the context in which it appeared online. In these circumstances, Google cannot determine which content is objectionable and which is legitimate based on context. Specifying a URL for de-indexing unlawful content was the only way to identify and de-index such content. Any other action would jeopardize legitimate and genuine content because automated means can't differentiate or exercise discretion, especially when content is illegal by context, when context made the content illegal. To make court orders effective, it was suggested on behalf of Google that the website hosting the alleged content may be ordered to remove or disable access to its URL. Once content is removed from websites, search engines will remove it organically. If a court or government agency deems the content illegal, they can share the URL for delisting or cache removal. On behalf of Ministry of Electronics and Information Technology, a detailed PowerPoint presentation was given. The Ministry of Electronics and Information Technology also suggested the following directions for removing the offensive content. Direct intermediary social media platforms to remove offending content, or direct the appropriate government or its agencies constituted under any act or rules, including the law enforcement agency, to get it removed, or grant the petitioner the right to directly approach or send requests via email to all social media platforms or appropriate government or police to seek removal of unlawful content. It was also submitted that online cybercrime reporting portal at www.cybercrime.gov.in, which was primarily intended for reporting pornography or child pornography or gang rape content, has expanded to include all cybercrimes, and any aggrieved person can report any unlawful content through its portal. In a case like this, Section 66E of the IT Act, a penal provision relating to punishment for violation of privacy, and Rule 3, Subrule 2B, E, Rule 3, Subrule 6, and Rule 3, Subrule 8 of 2011 rules are also attracted, and an aggrieved party can file a complaint for violation of privacy before the jurisdictional law enforcement agency. Law enforcement agencies have a role in protecting the individual's privacy. On behalf of Internet Service Providers Association of India, it was argued that ISPI had no power to compel, order, or regulate the functioning of its members except to encourage healthy self-regulatory practices. It was also argued that ISPI members are required by law to comply with blocking orders issued by the competent government authorities or a court, which they do. However, the members cannot regulate the content of any intermediary, social media, or otherwise. ISPI suggested ensuring expeditious global source blocking on the content provider or aggregator or platform intermediaries to prevent content mirroring. The ISPI argues that while a member can block a website under the direction of a competent authority or court, they cannot sift or monitor content or block it partially because they merely provide the technologically infrastructure on which a website or online platform functions. On behalf of Facebook or Instagram, submissions were made that Facebook has a strong privacy policy and follows global best practices to protect user privacy and ensure a safe online experience. It was added that Facebook or Instagram users have various privacy settings to restrict access to their content and lock their profile so others cannot view their photos or post nor zoom into and download their profile pictures unless otherwise permitted by the user. Facebook's profile picture guard and audience selector gives user more control over their profile pictures and other content and while Instagram has also similar features. In a short affidavit given on behalf of Facebook, it was said that it actively collaborates with the other stakeholders to remove unlawful online content and complies with the judgment passed in Shreya Singhal. It was also argued that Facebook has in the past and is ready and willing to cooperate with an aggrieved party and law enforcement agencies to remove offensive content in accordance with the applicable law and court orders. So how all these submissions were taken and how the law was in fact interpreted. First of all, Honorable Judge had taken into consideration the territorial jurisdiction and the penal provisions involved. It was observed that the IT Act has both extraterritorial jurisdiction and overriding application if the computer system, or computer network involved is located in India. Reading section 67, 67A and 67B together reveals that the IT Act punitive architecture. Section 67 makes publishing or transmitting obscene content in electronic form an offense. Section 67A specifies obscene material as material containing sexually explicit act or conduct and makes publishing or transmitting such material a more heinous offense with heightened punishment. Section 67B crafts an even more aggravated form of offense, bringing obscene material relating to children within its ambit with additional heightened punishment. Children are defined as those under 18 years of age. Next, the power of the designated officer to remove or block the offensive content was discussed. It was observed that Rule 10 of 2009 rules mandates a designated officer notified by the central government under Rule 3 to swiftly block any material when a court in India issues an order by transmitting the order to the Secretary, Department of Information Technology. Although the designated officer contemplated under Rule 2C, read with Rule 3 of the 2009 rules, is otherwise notified for blocking access to information at the instance of the central government in the context of Section 69A subsection 2 of the IT Act, which relates to sovereignty and integrity of India, defense of India, security of the state, and other similar matters. A plain reading of Rule 10 of 2009 rules nowhere restricts the power to block access to information on the orders of the court. Hence, the designated officer is required to act swiftly. The liability of intermediaries vis-a-vis removal of offensive content was also discussed. It was observed that Section 21W of IT Act defines an intermediary as a person who receives, maintains, or transmits electronic records for other person or offers any service related to electronic records. The definition encompasses telecom, network, internet, web hosting, and search engines. Section 79, subsection 1 of the IT Act exempts intermediaries from certain liability, but only if they meet specified conditions and obligations. Section 79, subsection 1 creates the exemption from obligation subject to subsection 2 and subsection 3. Subsection 2 outlines the conditions and requirements under which subsection 1 applies, while subsection 3 outlines those which it does not. So far, dealing of offensive content is concerned, it has been expressly laid out in the newly added Rule 7 of 2021 rules that omission by any intermediary to observe the 2021 rules shall expose it to penal consequences, both under the IT Act and under IPC. To emphasize the importance of removing or disabling access to offending content, even voluntarily, the central government has provided in the third proviso to Rule 3(1)(d) that removal or disablement of offending content by an intermediary on a voluntary basis upon knowledge or on grievance received by it would not amount to a violation of Section 79, subsection 2A or B of the IT Act on the intermediary's part, thus cementing the exemption. Judgment of Shreya Singhal versus Union of India was also referred to by the Honorable Judge, to wherein it was held that an intermediary loses its exemption from liability under Section 79, subsection 1, if it does not expeditiously remove or disable access to the offending content or material despite receiving actual knowledge, such as a court order or notification from the appropriate government agency, in this case, the police. Section 85 of the IT Act makes directors, managers, secretaries, and other officers of a company accountable for the breaches of the IT Act rules if they were negligent. So what are those exemptions from the liability available for intermediaries were also observed by Honorable High Court, which are summarized. That if the intermediary's function is to provide access to a communication system that transmits, temporarily stores, or hosts information, if the intermediary does not initiate the transmit, select the recipient, or select or modify the transmission information. If the intermediary maintains due diligence while performing its IT Act duties and any other central government directives, the exemption is not available if the intermediary has conspired, abetted, or induced the commission of unlawful act. The exemption is also not available if the intermediary fails to remove or block access to material upon actual knowledge or notification by the appropriate government or its agencies that a computer resource controlled by that intermediary is being used to perform an unlawful act. So, first 3 points are the outlines on which the exemption is available to the intermediary for the from the liability under section 79, and last to the point number 4 and point number 5 were the scenarios when the exemption is not available to the intermediary. Now, coming to the ratio of the case, that ultimately what was held by Honorable High Court in this case was that in this case, a petitioner's non-obscene Facebook and Instagram photos were published to a pornographic website with the nasty comments. If a person's name or likeness appears on a pornographic website without their knowledge or acquiescence, it is an offense under Section 67 of the IT Act. Inclusion of a person's name or likeness on a website without agreement or concurrence, even if the photograph is not obscene or offensive, would be at least be a breach of the person's privacy, which a court may injunct or restrain. The law and judicial opinion in India, as well as several other jurisdiction, mandates intermediaries to remove and disable access to offending content once they receive actual knowledge by way of a court order or upon being notified by the appropriate government or its agency, failing which the intermediary is liable to lose its exemption from liability under section 79 subsection 1 of the IT Act. An intermediary cannot claim that it can't remove offensive content despite legal awareness. Looking at the difficulties faced by the intermediaries in identification of the offensive content appearing in disguises or corrupted avatars, it was held that it would be too onerous and impractical to lay that obligation on them. However, for an order directing the removal or access disablement of offending content to be effective in India, a search engine must block the search result worldwide. Search engines also already use automated methods to block child pornography and hate speech links, which can be used to enable a court order like the one in the present instance, implementable and successful. None of this would require the website, online platform, or search engine to monitor material or assess the legitimacy of the content or censor content generally. So thereafter, Honorable High Court suggested a template of directions that should ordinarily pass by the court and against whom such directions may be passed if such scenario has come before a court to decide. So the court suggested that the following template of directions that should be ordinary issued and the parties to whom it be issued after striking a fair balance between the user rights, victims and interest and the intermediaries obligations and liabilities. The directions are as such: where a grievance is brought before the court under the 2021 rules or otherwise, and a court is satisfied in any proceeding before it, whether at the interim or final stage, that such grievance requires immediate redress, the court may direct the website or online platform on which the offending content is hosted to remove such content immediately and in any event within 24 hours of the recognizance. Website or online platform on which the offending content is hosted be directed to preserve all information and associated records relating to the offending content for at least 180 days or such longer period as the court may direct for use in investigation. The search engines Google, Yahoo, Microsoft Bing, and DuckDuckGo, as popular in India, be also directed to render the offending content non-searchable by de-indexing and dereferencing it in their listed search results, including de-indexing and dereferencing all related web pages, subpages, or subdirections where it is found. The intermediary must comply with the court orders to remove or disable access to offensive content within 24 hours. The concerned intermediaries, whether websites or online platform or search engines, be directed to mandatorily employ proactive monitoring by using automated tools to identify and remove or disable access to any content that is exactly identical to the offending content that is subject matter of the court order. The concerned law enforcement agency, such as the jurisdictional police, be directed to obtain from the website or online platform all information and associated records, including all unique identifiers relating to the offending content, such as the URL, account ID, handle name, internet protocol address, and hash value of the actual offending content, along with the metadata, subscriber information, access logs, and such other information as the law enforcement agency may require as soon as possible, but not later than 72 hours of the receipt of written intimation in this behalf by the law enforcement agency. Also, the court must direct the aggrieved party to furnish the law enforcement agency all available information about the offending content, such as its file name, image URL, web URL, and other identifying elements as applicable, with a further direction to the law enforcement agency to furnish such information to all other entities such as websites, online platforms, or search engines. On the strength of the court order, regarding specific offending content, the aggrieved party should be allowed to notify law enforcement to remove the offending content from any other website, online platform, or search engines on which same or similar offending content is found, whether in the same or a different context. Upon notification by the aggrieved party, the law enforcement agency shall notify the concerned website, online platform, and search engines who later would be obligated to comply with such request, and if there is any technological difficulty or other objection to so comply, the website, online platform, or search engines may approach the court which passed the order seeking clarification, but only after first complying with the request made by the aggrieved. The court may also direct the offended party to file a complaint with the National Cyber Crime Reporting Portal if not previously done, to commence the portal's grievance process. The court must refer to section 79(3) subsection A and B, read with section 85 of IT Act and Rule 7 of 2021 rules, which state that an intermediary forfeits its exemption from liability under the law if it fails to remove or disable access to offending content despite a court order. Accordingly, it was held by Honorable Delhi High Court that the petitioner's photographs and images being taken from Facebook and Instagram accounts and reposted on a pornographic website and then being reposted out to other website and online platforms amount to prima facie to an offense under section 67 of the IT Act, in addition to other offenses under the IPC, and that appropriation is an offense under section 67 of the IT Act. In line with the above suggested template of directions, the court issued the further directions for the removal of the content. It was also stated in the order that non-compliance with the above orders makes the non-compliant party subject to forfeit and exemption available to it under section 79, subsection 1 of the IT Act and Rule 7 of 2021 rules, and make such company and its officers liable for section 85 of the Act. Accordingly, the matter was disposed of. So this is a very beautiful judgment with regard to the removal or blocking content from the online platforms. And with this, I end my presentation till we meet again with another presentation on another case note. Namaskar.